We have heard 4 times, I think, with Minister Wilson-Raybould that nothing in this Act compels anyone to become involved in assisted suicide and euthanasia. That, I think, suggests that the time may be ripe that those words actually appear in this bill. Nothing in this Act compels. That could appear in the preamble. That could appear in another section. But I think that this would go a long way toward giving that central direction to conscience protection and protection of professional judgment, which is so desirable.
Dr. Johnston, regarding nothing compels a physician to in the preamble. Preambles are not usually seen as the court by the court as the guiding principles as it would be if it was actually in the bill. I think all of us have heard from witnesses the #1 issue that we're hearing over and over again is protect the conscience rights of physicians, nurses, pharmacists, medical practitioners. And we need to get it right where we protect vulnerable Canadians and we need to protect the conscience rights. Supreme Court in the Carter decision highlighted that. So it is at this point in the legislation as proposed in C14, it's silent on that, and it's been explained by the minister and the department that it does not say anyone is forced to participate in this, but it is silent on this. Would it help instead of having it in a preamble, but actually having it in the bill that it would be a criminal offense to force, intimidate, coerce a physician, healthcare practitioner, nurse practitioner, pharmacist, to make it a criminal offense to actually force somebody to participate against their will? Now, what we have in the Carter decision is it was legal to commit suicide, but it was illegal to assist somebody. Carter has said you can, under certain criteria, you can assist somebody. But the pendulum has swung to where the special committee said, well, you must refer. But I think Canadians that I'm hearing, is they want the conscience protected. So my question to you is, if C14 was amended to make it a criminal offense to coerce, intimidate, force a physician, do you think that would deal with the issue as far as conscience protection?
It is true that the strongest possible statement of conscience rights would be contained in a section of the criminal code which actually provided not just a ringing endorsement of the Section 2 Charter right to conscience, which has never been properly supported in jurisprudence that I'm aware of, but that would also provide actual penalties for the discrimination against a person who was contemplating entering a healthcare profession, was in a healthcare profession, was in any way involved in the care of a patient, and where that person was being coerced to either renounce their determination not to participate in assisted suicide and euthanasia, or to in any other way disadvantage that person. And so I would, of course, heartily endorse such a thing, and I think that it would be appropriate as a balance against this amazing innovation in Canadian law that a statement of exemption from criminal prosecution, which is as groundbreaking as the rewrite of Section 241, be accompanied by an equally groundbreaking assertion of conscience rights. And I would challenge the committee to take this up as a special issue, because this is not the last contentious thing that's going to come before us. Medical science and genetics will deliver so many more contentious questions to us in the future. And are the conscience rights of the relevant professionals or involved practitioners to be thrown under the bus every time a new access right is declared by a court or by Parliament? The time has come to decouple conscience rights from access rights. And this could most effectively be begun by a ringing endorsement of conscience rights and a protection of them in the criminal code.